think we'll open it up, the floor up for questions, and Rachel has a mic if anyone would like to ask a question. Ben?
First book I ever read by Akhil Amar was a book called The Constitution and Criminal Procedure, which has a pair of chapters on the Fourth and Fifth Amendments that present some original understanding of the Fourth and Fifth Amendments that are, I'd say, profoundly challenging to contemporary progressivism. And which is, while I accept that there's a huge progressive tradition in the Constitution, there are also these ideas in a historically and textually serious view of the Constitution that are very challenging to contemporary progressivism. The question is, so what do you do with that? I mean, how does an organization that's devoted to looking at looking at text and history seriously, but also committed to a contemporary progressive vision, do with those areas where the Constitution is just kind of, or constitutional adjudication is kind of wildly out of line in a just a different direction than that original understanding would be?
It's a great question, Ben. I mean, I think the first thing I'd say about that is I think you have to, if you're embracing text and history seriously, take text and history seriously. And if it points you in a direction that you don't like, you may not have to file a brief in that case, but you can't file a brief on the other side. And I think, on the other hand, Justice Scalia has gotten a great deal of credibility because there's times and places where he says, you know what, I don't like the result text and history gets me to, but I'm going to follow it. Now, he doesn't do that as much as he should. He doesn't do that in a lot of areas which compel him to, but he does do it in some areas, and I think that's an important part of why he's had, I think, an outsized influence. I mean, obviously, there's no, and I'll let Akhil speak about specific issues. I don't know every position Akhil has, and Constitutional Accountability Center will make its own judgment in each case as to what the text and history compels. But if we make a judgment that it doesn't compel an answer we like, we won't argue on the other side.
Doug, that sounds excellent from my point of view. Just a couple of quick things about the Fourth and Fifth Amendments that are worth mentioning, and maybe we could even throw in the Sixth, which are provisions about the rights of criminal defendants. Here's one thing about the Fourth Amendment. The framers cared about unreasonable searches and seizures and cared about providing full remedies for innocent people who were searched and seized, maybe and no evidence was ever found. And I think progressives may have missed a real opportunity in focusing only on the exclusionary rule and the rights of guilty defendants, and missed an opportunity to champion the rights of innocent people. No evidence is ever suppressed because it's not found, but that little old lady in Pasadena or an innocent person of color who's being abused, these people have constitutional rights, and the framers cared a lot about them. And today's judicial doctrine actually provides for government immunities in all sorts of situations where the framers, I think, would have been more protective of liberty and equality, too, because searches and seizures aren't just about privacy, although that's an important value, but about equality as well. An unreasonable search or seizure might be a policy where some people are targeted and others aren't. As for the Fifth Amendment, which talks in part about self-incrimination, the current court doctrine is very helpful for certain guilty folks, but actually is underprotective of the rights of innocent people in a whole bunch of ways. Hugo Black, remember, for example, fought to have, and here I'm talking about the Sixth Amendment, indigent defendants being protected by rights of counsel. That's the promise of Gideon versus Wainwright. Are we really carrying through that promise? If you're actually poor and innocent but poor, Are you really getting the sort of legal services that due process requires, that a fair trial requires, that a commitment to protecting the innocent against the possibility of erroneous conviction, which is a deep, deep founding value? Are you really getting that today? You were promised that by Hugo Black and by the Warren Court. Are you getting that? So even in the field of the Fourth, Fifth, and Sixth Amendments, I think it's interesting and complicated, but there's lots there for progressives to claim, it seems to me.
David? Go ahead,
I just want to add one thing to what Akhil said, and maybe this is sort of implicit, but it's worth pointing up, I think, that there's a lot of value in speaking the same language. And that it seems to me that one of the things that I learned from Doug's efforts with Jim Ryan at UVA to answer the parents' decision last spring that came down, and to answer it in originalist terms, was that when you don't, when you sort of seed the field and you say, okay, well, progressives aren't even going to talk about originalism, what you end up doing, I think, is giving enormous latitude to the people who are talking that language to set the terms. And one of the things that was really a useful exercise was to see Doug and Jim go through and say, let's not seed the field. Let's, instead of you using a measuring tape and we use a pinwheel, let's take out a measuring tape and see how parents fits your own doctrine. And it seems to me that's really an overdue process, and I think it's a very, very, very useful process. So I don't know that you need to concede as much as you need to say, at least we're now speaking to each other and we're both using the same measuring stick. And I think that is probably implicit in everything we've said today, but it's maybe worth unpacking.